the hearing. Should I then go through all the pro forma stuff or leave that until after we acknowledge Senator Kitching's passing?
It's up to you which order you do it in.
Okay. Look, we'll just I'll open the hearing and then we'll refer to Senator Kitching and then we'll move to the and actually I'll hand over to the Deputy Chair if that's all right with you, Mr. Khalil, to read out the pro forma advice to the witnesses.
Yep. No worries.
Okay, well, I'd like to now declare open this public hearing of the Joint Standing Committee on Treaties. Before we proceed to the substantive business today, I did just want to acknowledge the very tragic passing of one of our colleagues, a committee member and a colleague of all of us in the Parliament, Senator Kimberley Kitching, who passed away tragically and unexpectedly last night. I wanted to convey on behalf of the committee and all the members our most sincere condolences to her partner, Andrew Landrieu, and her many friends and family and supporters and loved ones. Many of us, I think, knew Senator Kitching personally and couldn't help but be struck by the warmth and effusiveness of her personality, but also the quality and insight of her intellectual and policy contributions on a number of parliamentary roles in which she served. And I, obviously, for those of her colleagues in the Senate, it's a particularly hard day. For those of her colleagues from Victoria, it's a particularly hard day, and for those of her colleagues in the Labor Party too. So I just wanted to reflect all of our collective sadness at this terrible news and to also convey our most sincere condolences to the family. And I know the Deputy Chair would like to say some words too, so I'll pass to him.
Thank you very much, Chair. And it is to many of us, and that included members and senators areas of national security and foreign policy, her commitment and her passion. This Parliament, through the committee processes in the Foreign Affairs Committee and other committees, to get Magnitsky laws up through our Parliament is a significant legacy achievement by her, and one that is being timely, frankly, and used in the sense of the contest that we have now against authoritarian states around the world. And that was because of Kimberley's efforts. We're all struggling at the moment. We're in a bit of shock at her passing, but she leaves a formidable legacy, and I think it's incumbent upon us to carry on that legacy in a legislative sense, the work that she has committed so much of her life to, and particularly her term as a senator from Victoria. I do also, for the record, want to obviously put our condolences on the record for her partner, Andrew, and all of her friends and family who are suffering right now, and also all the colleagues, not just in Victoria, Chair, but right throughout the Parliament. We're all in shock at her passing, and we hope that we can carry on much of her good work. Thank you, Chair.
Thank you, Deputy Chair. Deputy Chair, if you're, I'll recuse myself now from the meeting and rejoin shortly. So if you would be happy to take control of the proceedings in beginning to hear evidence from the witnesses and reading them their preambular statements.
Thank you, Chair. Thank you. I declare open this public hearing of the Joint Standing Committee on Treaties. These are public proceedings, although the committee may agree to a request to have evidence heard in camera, or may determine that certain evidence should be heard in camera. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated as a contempt of Parliament. It is also a contempt to give false or misleading evidence to a committee. Mobile phones should be switched off or on silent. In accordance with the committee's resolution of 29th of July 2019, this hearing will be recorded and broadcast on the Parliament's website, and the transcript of proceedings will be published on the Parliament's website. To assist Hansard in providing an accurate record of proceedings, any witnesses appearing by teleconference should identify themselves when they speak. Those appearing today are advised that filming and recording are permitted during the hearing. I remind members of the media who may be listening of the need to fairly and accurately report the proceedings of the committee. The transcript of today's proceedings may not be available in time to meet the deadline for questions on notice. Therefore, could you please keep track of any questions on notice so that you are able to respond at the time required to ensure the committee can meet its reporting deadlines. The committee will now take evidence on the proposed International Labour Organisation Protocol of 2014 to the Forced Labour Convention 1930. I understand we have some witnesses at the table there, if they could just introduce themselves.
Sharon Hunder, Assistant Secretary, Industrial Relations Strategy Branch, AGD.
Lani Rankin, Director of the International Labour Policy and Programs Team, AGD.
Eleanor Parlow, Assistant Director of the International Labour Policy and Programs Team, AGD.
Danica Yanchenko, Assistant Secretary, Workplace Compliance and Enforcement Policy Branch, Attorney General's Department.
Belinda Gill, Assistant Secretary, Status Resolution, Department of Home Affairs.
Greta Doherty, Branch Manager, Women's Safety Policy, Department of Social Services.
Frances Finney, Assistant Secretary, Modern Slavery and Human Trafficking Branch, Australian Border Force.
I welcome witnesses that are giving evidence today. For the Hansard record, you've obviously given your full names and capacities in which you appear before the committee. Although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and therefore has the same standing as proceedings of the respective houses. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. The evidence given today will be recorded by Hansard and attracts parliamentary privilege. I now invite you to make a brief opening statement if you have one before we proceed to discussion and questions. Would you like to start, Ms. Yanchenko?
I might actually pass to Ms. Hunder and also just note we have some colleagues on the line from a range of other agencies, Deputy Chair, including DFAT and the ABF. So I might actually just ask them to introduce themselves before we proceed. Thank you.
Good morning, Michael Bliss, Assistant Secretary, International Law Branch at DFAT.
Thank you.
Good morning, Commander James Watson, Maritime with the Australian Border Force. I'm Commander Maritime and Enforcement South.
Lucienne Menton, Ambassador, People Smuggling and Human Trafficking. Thank you.
Thank you.
And Commander Hilda Siric of the Australian Centre to Counter Child Exploitation and Human Exploitation, Australian Federal Police.
Thank you.
Deputy Chair, that's all the witnesses. So we do have an opening statement, but before we start, I would like to say on behalf of the officials here today that we would also like to pass on our condolences to the family, friends and colleagues of Senator Kitching on her sad passing. We know that she was an active member of this committee and will be sorely missed.
Thank you.
Thank you, Deputy Chair, for the opportunity to appear before you this morning. The Australian Government works actively to prevent and combat all forms of modern slavery wherever it occurs. Forced labour has no place in our communities or the supply chains of our goods and services, and Australia has long been a leader in contributing to global efforts to end this abhorrent crime. Ratification of the Forced Labour Protocol reinforces Australia's comprehensive response to forced labour and other forms of modern slavery. Effective measures to prevent and eliminate forced labour, including through the implementation of international labour standards, are even more critical at this time. COVID-19 has exacerbated the vulnerabilities to forced labour and other forms of modern slavery and made it more difficult to reach people who need support. Ratification of the protocol would ensure that Australia has ratified the most contemporary international labour standards on forced labour at this critical time. Australia has already ratified the Forced Labour Convention and the Abolition of Forced Labour Convention, which together provide the ILO's framework for the elimination of forced labour globally. Ratification of the protocol, which modernises and supplements these conventions, would ensure that Australia's adoption of the international labour framework is comprehensive and responsive to modern forms of slavery. Sadly, many people in our own region are subject to these practices. The Asia-Pacific region accounts for almost half of the global estimated number of victims of forced labour. Ratification of the protocol would strengthen Australia's credentials and support our efforts in the region to promote stronger measures to prevent and eliminate forced labour. Australia would join 57 other countries in ratifying this protocol, including many of our key partners in the global fight against modern slavery. The Australian Government played a lead role in the drafting and adoption of the protocol, and we are pleased to now be able to take steps towards its ratification. Following amendments to Western Australia's industrial relations laws in December last year, I'm pleased to confirm that the law and practice across the Commonwealth, state and territory levels is now compliant with the obligations of the protocol. Australia's compliance with the protocol is primarily met through Commonwealth measures, and I'd now like to highlight some of these actions now. Australia's National Plan to Combat Modern Slavery 2020 to 25 provides a strategic framework for Australia's response to modern slavery, building on the achievements of past plans. Australia comprehensively criminalises human trafficking, slavery and slave-like practices, including forced labour, with penalties of up to 25 years imprisonment. In addition, the Fair Work Act sets out minimum employment conditions and standards that must be met by employers and contains specific protections for vulnerable workers, including migrant workers, from exploitation. The Australian Federal Police employs a combination of prevention, disruption and enforcement strategies, with specialist teams in the AFP trained to identify victims and to prevent and disrupt modern slavery and investigate these offences. Under the National Policing Protocol to Combat Human Trafficking and Modern Slavery, these teams work collaboratively with state territory police forces to combat all forms of modern slavery. The government also provides a range of support services based on needs, including secure accommodation, medical treatment, financial assistance, and access to legal and migration advice to all victims of modern slavery offences identified and referred to the AFP. Australia has a whole-of-community response to modern slavery, exemplified by the collaboration between the government and civil society, business, academia, unions, through the National Roundtable on Human Trafficking and Slavery and the Modern Slavery Expert Advisory Group. We also note the important role that our social partners, the ACTU and ACCI, play as partners in our efforts to prevent and eliminate forced labour. We recognise the important expertise these partners bring to the design and implementation of international standards as key tripartite members of the ILO. Additionally, Australia's Modern Slavery Act 2018 drives business action to combat modern slavery in global supply chains by requiring large businesses operating in the Australian market to report on their steps to identify and address modern slavery risks. Australia also has an active agenda of bilateral, regional and multilateral engagement on preventing and eliminating forced labour. Australia's ministers, our Ambassador for People Smuggling and Human Trafficking here today, and our diplomatic network conduct targeted and careful bilateral advocacy on this issue. Australia also promotes international cooperation to end forced labour at the multilateral level, including through the UN Human Rights Council, UN General Assembly and other multilateral fora. Regionally, Australia co-chairs the Bali process on people smuggling, trafficking in persons and related transnational crime and its subgroups. In addition, Australia undertakes a number of regional activities under Australia's Official Development Assistance Program to deter modern slavery and train law and justice officials, promote stronger laws in the region and assist victims. Ratifying this protocol will highlight the importance Australia places on addressing forced labour and demonstrates Australia's ongoing commitment to the implementation of key international instruments and the global rules-based order. Thank you, Deputy Chair.
Thank you very much. I might just start with a couple of questions. You alluded to, I think, in the opening statement, the issue of forced labour in Australia and the numbers. Can you just clarify what's the estimates that AGD and the government have of the number of people in forced labour in Australia?
Frances Finney from the Australian Border Force. In terms of reports of modern slavery received to the Australian Federal Police, forced labour offences, if I can read some from the financial year 2017 to 18 were 25 reports. Financial year 2018 to 2019 were 29 reports. 2019 to 20 was 29 reports, and 2020 to 21 were 35 reports. That's for sorry.
No, go on.
That's for forced labour, but there may be other reports of other related modern slavery offences, such as trafficking, for the purposes of forced labour or domestic servitude and so forth, that are also relevant. I might just check if my AFP colleague has anything they wish to add on that.
Thank you. Hilda Sirik from the AFP. That's correct. The statistics are correct. And in total, the AFP in the 2021 calendar year has received 43 reports of forced labour, 5 reports of debt bondage, and 3 reports of deceptive recruiting. Quite often, human trafficking offences are looked in totality across the different human trafficking and modern slavery aspects. And in total of that, since 1 July 2021 to 28 February 2022, the AFP has received 209 new reports of human trafficking and modern slavery.
So that's the reporting going to your organisations. I mean, there are a number of other estimates from various organisations around the world, whether it be the ILO or the Global Slavery Index, that talk about the victims of modern slavery in Australia being estimated to be around 15,000. Is that a accurate reflection of where the problem is? And is your reporting, do you see sort of similar percentages of reporting when it comes to other types of offences? Because that seems quite low in comparison to the estimate of the total problem of modern slavery in Australia.
Yes, the National Action Plan recognises previous reporting that for every victim of modern slavery in Australia that who is detected, there are probably another 4 who are not yet detected. So detection and disruption are some of the priority areas in addressing this. I think the international estimates, yes, would be relevant and accurate to the picture. In terms of actually the forced labour as one of the modern slavery offences being reported, the one that is the highest report is for forced marriage. So forced labour comes in at about 3rd or 4th in terms of reporting of modern slavery offences.
Thanks. Obviously, there are a number of factors that contribute to or are drivers to modern slavery persisting. You've got the whole gamut, poverty, underemployment, displacement, discrimination, all of those issues, lack of education, workplace conditions, and so on and so forth. Which of these factors, what are the predominant factors with respect to the cases in Australia? What's really driving our modern slavery problem?
I think that would be several causative factors in terms of trafficking to Australia, also the detection of these practices. In terms of underlying causes in Australia, one of the areas that the National Action Plan brings together is to make sure that the continuum of decent work through to substandard work conditions that could contribute to issues of modern slavery and forced labour, if left unchecked. That's one of the factors in terms of detection, but also in terms of prevention. So there are a number of causes, but yes, and they're also set out in the plan.
And could you just describe for the committee how the protocol works to address those particular factors, the substance of the protocol?
Yes, it's Lani Rankin here.
Or how it would, sorry, after ratification, I should say.
Lani Rankin from the Attorney General's Department. I'm just finding the right page. So in terms of the root causes of trafficking in person, and this relates to Article 2F of the protocol, under the National Action Plan to combat modern slavery, the government undertakes a wide range of initiatives to tackle the root causes of exploitation. We have many programs to raise awareness amongst the general community and to build the resilience of groups who may be vulnerable to these practices. We also have, through our DFAT programs and aid programs throughout the region, programs aimed at the root causes of modern slavery, and we also contribute to the international standard setting in many fora, including, of course, this forced labour protocol, which Australia was a key driver of back in 2014, and that we're very keen to promote throughout the region and to ratify.
The other question I think is of interest is what we're doing actually to address forced labour issues, not so much in our country per se, but in the supply chains of products sold in Australia.
Yes, with the Modern Slavery Act, that is one of the measures in the National Action Plan that takes steps to address the causes of modern slavery in supply chains, both in Australia and internationally. So the Modern Slavery Act requires entities and businesses who are undertaking business in Australia to report on the risks they've identified in their supply chains of modern slavery, and to describe the actions that they're taking to address those risks. In terms of the actual numbers of entities that are reporting, they're publicly available on the online register for modern slavery statements. So we have at the moment over 8,000 entities reporting from either a mandatory or voluntary perspective.
Thank you. And just going back to Australia itself, what are the main parts of the Australian economy or the sectors in which you're seeing forced labour or compulsory labour being most prevalent?
I think it depends on the actual business that is being conducted. So different entities would describe different risks based on sectors. Certainly in relation to sectors that we're aware of at the Commonwealth level, it's looking at sectors such as our IT, hardware, the cleaning and security sectors, construction, and also textiles and others. So some of that is we have to look at the supply chain. The first tier of the supply chain may be in Australia, but subsequent tiers may be overseas. So I think it depends on the actual product and supply chain that is being examined.
And my last question before I go on to other members of the committee relates to, I guess, the question before, which was when you recognise or you identify, detect, as you call it, forced labour occurring in certain supply chains for products that are sold in Australia. Maybe explain to the committee a little bit about whether you've been constrained in taking actions because of those particular countries. I guess what I'm saying is your ability to take actions to investigate, to even detect at some level, constrained by the particular countries in which those supply chains, where the products are coming from. And maybe talk a bit about where you've been more successful, and is there any way we can actually kind of assist in that in a diplomatic sense with those particular countries, and whether if the protocol doesn't quite do that job?
Look, I think I might start and then invite other colleagues to join in, particularly on the international side. But with respect to detection and identification in supply chains, the work that we're doing at the Commonwealth level is very much, it's outlined in the Commonwealth's modern slavery statement, which is looking at the discovery phase, if you like, which will then move into the implementation of what risks that have been detected and then what actions will be taken in the subsequent years. In terms of forced labour, the premise of the Act and the work that we're encouraging both within government and business entities is to adopt the approach of the UN Guiding Principles on Business and Human Rights and other guiding protocols around trying to influence and exert leverage on those supply chains. So where those issues are detected, whether it's forced labour or other forms of modern slavery, the intention is to identify them and then to work together to try and influence the behaviours or the underlying causes of those causes of forced labour, and try to get a better outcome and resolve those cases and refer them accordingly if they're detected.
Thank you. I'm going to move on to other members, but before I do so, I just remind witnesses, if you could please identify yourself prior to speaking, because I know there's some of you are in one room, and just for Hansard, for the record, we just need to know who you are. It's a bit tiresome if you've already spoken and you're going to say it again, but if we're moving from one witness to another, it's kind of necessary to properly record your comments. I will move across, I think, unless there's a government member of the committee that wants to say something or ask a question. I know Josh Wilson, Mr. Wilson, would like to ask a few questions. Mr. Wilson?
Thank you, Chair. And before I ask some questions, I'll just endorse what you and the Chair said in relation to our colleague, Kimberly Kitching. Very hard news to hear about Kimberly, and condolences and best wishes to her family. I want to ask a question from a practical point of view. We know that we have a problem still with modern slavery. Australia, one area where it occurs is clearly with people who are in Australia as visa holders, sort of short-term migrants, and particularly temporary foreign labour, I guess, holiday makers and international students. Is it right to say that in that situation, their primary and principal opportunity for assistance or their recourse to action to address instances of modern slavery is the Fair Work Ombudsman?
Thank you. So Danica Yanchenko from Attorney General's. Certainly the Fair Work Ombudsman is one avenue for support, particularly for things like wage underpayment and other sort of conditions in the workplace, but I wouldn't say that it's the only avenue for support. There are a range of social organisations in the country, and certainly the AFP for criminal conduct, where migrants and indeed any worker in Australia can go for assistance. The other point that I'd make is indeed the Australian workplace legislation applies to every worker in Australia, not just not just Australians, including migrant workers, regardless of visa status.
Yeah, I appreciate that. So if just take an example, you're a working holiday maker, you're coming in from, say, the UK, or you're someone who's coming in through a sponsored work program or another short-term temporary foreign labour program, are you given a pack or a card or something that essentially says, if you experience any of the following, take the following action? If it's criminal conduct, if it's assault or that behaviour that falls in the criminal category, contact the police. If it's underpayment of wages or other things that are more in the employment space, contact the Fair Work Ombudsman. Are people, as a matter of standard practice, given some pretty simple information and guidelines that allows them to seek assistance?
I might see if any of my colleagues from elsewhere in the Commonwealth can assist, but certainly with respect to, say, the seasonal worker program, the employees that arrive in Australia are given an on-arrival briefing by the Fair Work Ombudsman, and there's also information they're referred to on the Fair Work Ombudsman's website, and there's a hotline as well where they can go and receive assistance, and that information is available in a range of languages as well.
It's Belinda Gill from the Department of Home Affairs. In terms of the types of information that Home Affairs provides to workers in Australia, we've had a range of communication initiatives, everything from awareness raising through the department's community liaison network, doing visa outreach, and also through our compliance programs. We have information incorporated into visa grant letters about worker rights, and also through individual reminders to clients through their immigration accounts. And then I guess in addition to that, broader communications through social media channels. And then there is a fair bit of information available online through the Department of Education, Skills and Employment website on Harvest Trail Services. So I guess focusing in on some of those workers in the maybe agricultural sector, where as a part of the information available to people to help find opportunities, there's links to Home Affairs, the Fair Work Ombudsman, ATO information to help make sure that temporary visa holders can access more information as issues might arise. There is also an opportunity there, I suppose, on the other side for employers through the department's Visa Entitlement Verification online service, which is where employers can and are strongly encouraged to check whether or not the person they're employing has work rights as a part of their visa. And then I think, as Danica has pointed out, the Fair Work Ombudsman has quite a significant amount of promotional material available through their channels. The other avenue in terms of the Australian Border Force is the Human Trafficking Contact Officer Network. And that's quite a broad program in terms of we have subject matter expertise in the ABF who are trained to understand more and in more depth about human trafficking and related issues in terms of modern slavery. And the Human Trafficking Contact Officer Network is then available across the department and the Australian Border Force for other employees to reach in when they identify risks or issues, when they see people that might be showing some indicators or signs that there could be a modern slavery or human trafficking risk behind what's happening for that person. In addition, we provide a fair bit of training, and that goes not just internally within the department, but also through to community and industry. So I think, for example, in the last the better part of this financial year so far, we've had training sessions to community organisations, including I think a good example of how we try and get coverage into the communities is through human trafficking contact officers outreach. So they will do community engagement. I think we had sessions late last year with examples of the sorts of organisations attending the Muslim Community Association, the Women's African Group. We had community leaders from the New Zealand and Pacifica communities, from Myanmar communities, and also multicultural service centres. So I guess the strategy, so to speak, or the efforts we make on awareness are targeting individuals, community and employers.
Okay. So this is part of the preparatory material provided to committee members that, there was a 2018 study of certainly of international students and working holiday makers, and it found that fewer than 1 in 10 ended up recovering underpayment of wages. So I guess on the one hand, what we have at the moment, we have a series of measures and steps and information provided, and these various different avenues down which people can go. At the other end, some evidence, at least, of the actual experience, and there's some disparity. I mean, we don't want a situation. It's not consistent with what our obligations, I would say, our values. If you've got people who are vulnerable to forced labour or in a labour relationship, and less than 10% of people experiencing some form of mistreatment of that kind are actually even taking action to have it addressed, receiving some kind of recompense. So I'm just not sure. It doesn't seem to me, based on that evidence, what we're doing at the front end, what we're doing in between times, like perhaps to some degree it's partly an issue where you've got a self-help model where the onus is on people to pursue a remedy in circumstances where they are relatively powerless, resources, etc. Whether there are other things that need to be considered that are a bit more proactive, whether it's spot checks or other kinds of auditing or intervention that goes out there and a bit more actively roots out these problems.
It's Lani Rankin from the Attorney General's Department speaking. Just before I'll pass over to Danica for any further information, including in relation to any spot checks. I did just want to provide some updated or some information from the Fair Work Ombudsman, and I suppose this relates to Article 4 of the protocol. And the way in which Australia meets Article 4 is by way of ensuring the victims have access to civil mechanisms such as the Fair Work Ombudsman and Fair Work Commission, and with the ability to pursue civil and administrative remedies, including for unpaid wages and entitlements. And during the 1920 financial year, in relation to migrant workers, the Fair Work Ombudsman recovered over $1.7 million in unpaid wages for 494 migrant workers, and this included the Fair Work Ombudsman issuing 85 compliance notices and 98 infringement notices. In the 1920 financial year, the Fair Work Ombudsman filed 24 litigations and secured approximately $3 million in penalties, as well in matters involving migrant workers. The Fair Work Ombudsman has litigated cases for migrant workers who had already returned home to their home country and arranged for back pay to be sent to migrant workers in accordance with payment plans. And the Fair Work Ombudsman can also hold back pay for workers who can't be located, and uses various methods to trace the employees to ensure outstanding entitlements are paid. But I'll pass over to Danica if there was anything to add in particular about the more practical things.
Thank you. Danica Yanchenko from Attorney General's. So obviously don't want to speak for the Fair Work Ombudsman since it's not represented here today and is obviously independent of government, but would support everything Ms Rankin has articulated there, and also note that the Fair Work Ombudsman can and does undertake proactive audits of particular companies or industries where concerns come to their attention and otherwise through particularly as well has a very strong relationship with the AFP, and I understand that relationship goes both ways. So if information comes to the attention of one organisation, it will be shared appropriately with the other.
Okay, I've just got a couple of questions about the way we deal with supply chains. I'm sure there'll be other committee members, so I'll just try to be quick. I mean, I'd like, if I could just ask on notice, I think it would be useful for the committee if DFAT would provide to the committee in sort of table form a summary of the development assistance programs, funding allocations that either purely or in part go to how we address this issue in our region. I'd just be interested to see that. But I would ask for a kind of response with respect to the effectiveness of the Modern Slavery Act, which is relatively new. We considered that going through the Parliament not that long ago. There's a recently published report which was based on evidence gathered over 2 years, a pretty thorough piece of work with the Human Rights Law Council and a number of other contributing organisations that have found that the Modern Slavery Act is failing us. I mean, the stats are eye-wateringly bad. I mean, to have a situation where 77% of companies aren't complying with what are described as mandatory reporting requirements, and how they can be described as mandatory reporting requirements when less than a quarter of the companies that are obliged to report are doing so. That's right. More than half of companies failing to identify or disclose obvious modern slavery risks. Only 27% of companies, that's just slightly more than a quarter of companies, are demonstrating some form of effective action to address modern slavery risks. So to the extent that we are told on the committee that the adoption of the Modern Slavery Act is a key piece of our action to resist and combat modern slavery outside Australia, to which wittingly or unwittingly support through supply chain activity. Those statistics tell us that the Modern Slavery Act is not working. What's being proposed to address the fact that more than 3/4 of the companies that have mandatory reporting requirements aren't adhering to those requirements? How could they be described as mandatory?
Frances Finney from the Australian Border Force, if I may respond to that. The research that you refer to is very welcome, and indeed we actually thank the researchers for undertaking that work, and we've actually had a briefing on that work, and that has also been provided to the Modern Slavery Expert Advisory Group. Just in terms of, if I may just expand on some of the statistics and the approach, the research that I think that you're referring to was looking at 102 entities under the first reporting cycle of the Modern Slavery Act, which concluded on the 30th of June 2021. When we've looked at the statistics from Australian Border Force for the first reporting cycle, there are a few things here. The first point is that the first period of the Modern Slavery Act reporting cycle was designed to reach out to business, to educate and to uplift the capability of entities to comply with the Modern Slavery Act. In so doing, as statements were being properly submitted to the online register for modern slavery statements, the Australian Border Force has been publishing both compliant and non-compliant statements to maximise the transparency, to enable this visibility of how entities are performing under the modern slavery mandatory reporting criteria. With respect to statistics, after the first reporting cycle that finished on 30 June 2021, as I mentioned, our analysis has been, if I can speak generally, of those mandatory reporting criteria, approximately 40% have not met one or more of those mandatory reporting criteria. When you're looking at a broader base of almost 2,000 statements, so about 1,700 statements after that first reporting cycle. So the idea in terms of the approach to compliance with the Act was to encourage businesses, and the ABF has written out to those entities that didn't comply to give that feedback and to provide additional guidance and to get sort of have an approach of uplift for their next reporting cycle, their next statements, to improve on that. The other aspect to this is those.
Can I just ask, just at that point, just out of interest, what happens if they don't?
So if they don't, the Act provides for compliance action. So first of all, step one is about uplifting the capability for reporting. Then if that capability, if it's demonstrated that there is no improvement and despite all of the extra guidance and advice and support that entities are not meeting their mandatory reporting criteria, there is provision under the Act for the Minister to either require an explanation as to why certain criteria have not been met, or to request a remediation to a company's performance. In building that approach, the Minister must be reasonably satisfied that there is an issue there with compliance, which goes to the uplifting of the capability. And then if in that process, if the entity is not then responding to either the request for an explanation or the request for remediation of activity, the Minister then has further powers under the Act to publicly disclose that non-compliance. So it's a building of capability. It's a working with business. The Act was intended, particularly over that first cycle where this was very new for all entities or most entities, to build the capability, work with those entities around those compliance issues, and then leading towards where there is an absence of meeting mandatory criteria, the provisions then to exercise further compliance or compliance action that is delegated or held by the Minister. The other point that I will make in terms of compliance action, so there's the uplift of performance under the Modern Slavery Act, but the priority has been for identifying any entities that have not submitted a modern slavery statement, because you can't uplift a capability if entities are not engaging. So that's been an area of focus that ABF has been working on, in addition to providing that feedback on the mandatory criteria. So there's quite a lot of work happening in that space.
Chair, I have maybe one or two other questions. I've had quite a bit of time, so I'll let other people.
Mr. Wilson, I'm happy if you proceed, unless there. I know Mr. Broadbent's on the call, and the Deputy Chair, Mr. Khalil, but I'm happy.
Yeah, I've got just one more area, I guess, which when we think about areas of economic activity in Australia that involve supply chains and imports, where there are inherent risks of modern slavery, one of the areas is fisheries, overseas fisheries and imported seafood. I think it's 65 or 70% of all the seafood that we consume in Australia is imported. More than half of that comes from fisheries that have long identified chronic issues of a number of kinds. Some of them are, say, environmental, but some of them are certainly in the modern slavery, labour rights and labour conditions space. I'm just interested, one of the things that other countries, both the European Union and the United States, have done is introduced sort of a framework that are often referred to as IUU frameworks, seeking to combat illegal, unregulated and underreported fisheries activities. Australia doesn't have such a framework. That's been raised over the last couple of years by a number of organisations, civil society organisations in Australia, about why we wouldn't go down that path. I mean, I think it's been noted that when you look at catch to plate traceability, Australia only requires the collection of 2 out of the internationally recognised 22 different pieces of information that some other jurisdictions do require in order to seek to combat some of the very poor environmental and human rights activities that go on in unregulated fisheries. I'd just be interested in a response on our approach to that particular part of the supply chain problem, and whether or not it's under consideration that those kinds of IUU laws or an IUU framework, which does already exist, as I say, in covering the EU and the US, whether that's been under consideration, considering the significant proportion of seafood that Australians consume is likely to be coming from places that involves degradation of oceans, biodiversity, but particularly involves chronic, rife, modern slavery practices.
Hi, it's Ellie Palahi from the Attorney General's Department. In terms of obligations under the protocol, I understand you're getting at the obligation of the protocol to support due diligence by both private and public sectors. And Australia meets this obligation through its Modern Slavery Act, and we'd have to take on notice your question about efforts in that particular sector.
Okay. Yeah, I mean, I'd be really interested if there's been any consideration given to that those frameworks elsewhere have been established for some time, and there's no doubt. I mean, the evidence that we're given, like if you look at the material that Walk Free provides, we can easily identify certain categories of economic activity in which Australia participates significantly that involve modern slavery practices, and for lots of reasons, fisheries and maritime activity is right at the top of that list. So I understand, it's a bit of a niche question, so I'm not expecting you to be full bottle. I would appreciate anything that you can on that. Thank you, Chair. That's it from me.
Mr. Wilson. Are there other questions from Mr. Broadbent, if he's on the call, or the Deputy Chair?
None from me, thank you.
Mr. Colella, are you still there? Look, I had a
yes, I am,
question.
Chair. Sorry, Chair. I asked a number of questions.
Okay, you're already done.
Yeah, thank you very much. Cheers.
All right, thank you. Look, I just had a few questions, and my apologies, some of these may have been covered in the earlier question. I just had to step off the call for a short period. I just wanted to understand a little better, if I could, the specific gaps that this particular protocol addresses, because I note that there is the Forced Labour Convention of 1930, there's the Abolition of Forced Labour Convention 1957, which are obviously addressing similar issues. What does this protocol, one, require members to do, and two, seek to outlaw or prevent that isn't currently done by the existing 1930 and 1957 conventions?
Thank you, Chair. It's Lani Rankin from the Attorney General's Department speaking. The key purpose of the protocol is to take a more comprehensive approach to forced labour by focusing on prevention, protection and remedy. So these are issues which were not addressed by the Forced Labour Convention in 1930. The protocol also affirms it applies to human trafficking that results in forced labour. The preamble explains, the preamble to the protocol, that is, explains that it seeks to address gaps in the implementation of the Forced Labour Convention by reaffirming measures of prevention, protection and remedies, which are necessary to achieve the effective and sustained suppression of forced or compulsory labour. So that's what the protocol is aiming to achieve.
Okay, thank you. And I was just looking through some of the background paper. I understand that a number of the Abolition of Forced Labour Convention, which is the one from 1957, I noticed that just in the background paper that a number of countries didn't ratify it, including developed and OECD countries like Japan and South Korea, and also that Singapore withdrew from the convention in 1979 and Malaysia in 1990. Can you just explain the background of that? Have I got that correct? If I can, please.
The Abolition of Forced Labour Convention 1957, 176 countries have ratified that ILO's Abolition of Forced Labour Convention. Is that the one you're referring to?
Yeah, that's right, yep. Yeah.
Right, but unfortunately I'm not able to speak to why another country hasn't ratified. There are 187 members of the ILO, so 176, so it is nearing universal ratification. The Abolition of Forced Labour Convention and similarly 179 countries have ratified the original Forced Labour Convention from 1930, but yeah, I couldn't speak to why another country hasn't ratified.
Yeah, look, it seems here from what I've got here that Singapore is no longer a party to the 1957 convention, nor is China, nor is Japan, nor is Korea, nor is Malaysia. Have those countries indicated or what is their position on the 2014 protocol to the 2030 convention? Have they deposited an instrument of ratification?
In terms of the 2014 protocol, we have 57 members. So I'm just looking at the list. I don't see China, Singapore, or Malaysia at this point having or Japan having
or
ratified.
Japan or Korea?
No, I would say it is quite a new protocol. I mean, 2014, but it's possible that countries are still considering and taking steps. But I, again, probably would not be so bold as to speak on behalf of another country as to why or where they're up to on that in that process.
But do we know what the intentions of those other countries are? I'm just curious because Japan and Korea are close economic and commercial partners of Australia, Singapore as well, of course, and strategic partners. I'm just curious to know, obviously they had objections to the 1957 convention. I'm just wondering, do they have similar objections to this protocol, and if so, what are those objections? If you don't know the answer, I'd appreciate it if you or DFAT could take it on notice.
Yeah, I'm not aware of any objections. I'll just check with DFAT if they have any further insight into that.
Thank you very much. I suggest we take that on notice. Thank you.
All right, thank you. I'm just curious because it seems a little bit anomalous. I'm not sure what the concerns these countries would have about these issues, but I'm curious to know because maybe it's relevant to Australia as well. In terms of what the optional protocol requires under Australian law and practice, what is the task there in terms of either legislation or just more broadly operational practice?
Chair Sharon from the Attorney General's Department. Australia is now compliant with the protocol, so we're not required to do anything. Anything we do from this point would enhance our compliance with it, but at this point we are compliant with the protocol.
Okay. And including in terms of enforcement and oversight mechanisms? Making sure
yes.
we're... Okay. Sorry, go on.
I was going to say, the ILO do require us to report regularly on our compliance with the protocol and with any of the ILO conventions that we do ratify. So for fundamental conventions, and I assume the protocol will come under that because the Forced Labour Convention is a fundamental one, we're required to report every 3 years. We do that through, it's Article 22 of the ILO Convention. There's a template that we work through with our states and territory colleagues and our Commonwealth colleagues, which does an assessment of any new developments over the period in which we've ratified and or reporting, and any case law that's emerged, any new developments, and law and practice report effectively.
Okay. Yeah, I was just going to ask, what is the frequency of reporting required under the protocol?
So it will be 3 years.
Every 3 years. Okay. And is there like a sort of universal periodic review type process like exists in the Human Rights Council? Do we turn up at the ILO headquarters and we're asked to discuss our report by other member states or protocol signatories?
Somewhat different, Sharon Hunda, AGD, somewhat different in the ILO context because it's a fairly unique tripartite arrangement. So we do our Article 22 report, and we do that on all the conventions that we've ratified, and we do it on a cycle. So fundamental ones we need to do every 3 years. The remaining conventions we do over a 6-year period, sometimes a bit more frequently. We provide those also to our social partners, to the ACTU and ACCI, to make any comments on them before we submit them to the ILO. Those social partners also then have the opportunity to make any further comments directly to the ILO. The report then goes to a committee of experts who are eminent legal practitioners in the area of labour law, and they appear in their individual capacity, so usually academics or jurists, and they will do an assessment of that year's reports, and then they prepare a report based on their assessment of our reports. From there, so their report is published. From there, the ILO will select 25 countries or cases that will then go to another committee of the ILO, the Committee on the Application of Standards. And that committee appears at the, or is convened at the International Labour Conference each year. And that has members of governments, members of employer associations, and members representing workers. And at that point, that selection of 25 cases will be examined in detail.
Okay, thank you. And then just in terms of the history of this, so the protocol was negotiated in 2014, is that right?
Yes, that's correct.
Okay, and when do we indicated our intent to ratify it in 2017, is that right?
That's correct.
Okay. What's been going on between 2017 and 2022?
Ensuring Australia is compliant, because we do wish to ensure that we're compliant before we ratify either a convention or a protocol. So the key piece has been the implementation of the Modern Slavery Act, and then more recently some amendments that Western Australia have made to their industrial relations laws, which have made us compliant. So we've that happened in December last year. So we've actually moved very quickly as soon as Australia has been found to be fully compliant.
Gotcha. Okay, so there was state and territory legislation that had to be amended as well.
Yes, correct.
Okay, all right. And in terms of just our reporting under this protocol and monitoring and making sure we're adhering to our obligations, which part of the government does that sit within? Which department, or who's sort of the responsible entity for this?
So Attorney General will lead the reporting on this one. However, we'll do it in consultation with the agencies who are here today, so Australian Border Force, Home Affairs, DFAT and the like.
Okay, all right. That was all I had by way of questions. Mr. Wilson, you believe you had another question?
Yeah, just to pick up what you were asking there, and as a Western Australian, along with Fox on the call, I was just curious about the hold up with the Western Australian amendment. So I guess just as a matter of treaty making technical understanding, is it really the case that, I mean, surely we're not prevented from ratifying if there's a matter of state jurisdictional compliance has. I mean, I presume that's more a matter of our preferred approach. We would rather ratify something when we've ticked all of the boxes rather than ratifying something that then provides further obligation on us to tick all of the boxes. I can't imagine that but for one of the state or territories dragging their heels on a piece of their own law, the Commonwealth would be sort of forestalled from ratifying an agreement. Their description?
Sharon Hunda from Attorney General. Certainly there's not a requirement from the ILO that we need to be compliant before we ratify, but it's been certainly a matter of custom and practice that we would be compliant prior to doing so. I'm not sure if DFAT would like to add to that in terms of general practice.
Certainly. Michael Bliss International Law Branch, DFAT. That is our practice across the board, regardless of the subject matter, to ensure that we have our ducks lined up, if you like, in terms of state and federal legislation prior to becoming party to a international obligation, in this case, a treaty.
Where it's a matter of our reputation and timely response to international agreements of significance, we presume that when the Commonwealth does want the states and territories to help us as a nation get our ducks in a row, there's the capacity to encourage that. I mean, I'm just a bit curious because there's two things in our papers that make sense of us taking this action now. One is the reference to the fact that the WA government only passed that legislation late last year. And it just seems odd to me that if we made the decision we really wanted to get on with it once the Modern Slavery Act was passed in 2018, that it seems odd to me that the Commonwealth wouldn't have prevailed upon the Western Australian state government to do what it did last year. If that's not the case, I'd be interested to know it. If it's the case that the Commonwealth the last 3 years has been saying, guys, get it together, and WA, we're in no hurry, you'll just have to wait. I'd be interested to know that. The other thing now that suggests that one of the pieces of impetus for the ratification now is the fact that the UK government, it almost suggests that us ratifying this agreement is a kind of a condition precedent for the US, for the Australian-UK free trade agreement.
It's Lani
scheduled to be disconnected automatically.
Okay. I'll continue. Hopefully I don't get disconnected automatically. It's Lani Rankin from the Attorney General's Department. So as my DFAT colleague said, it is Australia's practice to only ratify an international treaty once we are satisfied that Australia's law and practice, including state and territory laws, comply with its terms. So we have, in fact, been waiting on Western Australia to take steps to bring their legislation into compliance. Western Australia identified the compliance risk itself, and we have at the Commonwealth level been working with our Western Australian colleagues in relation to this. They did introduce a bill at an earlier time, so in June 2020, Western Australia introduced legislation, but it lapsed due to the WA Parliament being prorogued for the state election. And then the WA government again introduced the bill, which was subsequently passed in 2021. So certainly from our perspective, from the department's perspective, we have been waiting on the WA legislation, and the WA government had been taking steps to make that change. Just it, by virtue of various parliamentary processes, took a bit longer than we would have liked.
Well, look, I guess I just put on notice. I understand that most of that kind of answer was summarising the fact that we wanted waiting for them. I would be interested, if you don't mind, taking on notice timeline of the kind of the communication that happened between the Commonwealth and the state government. I'll just be a bit curious as to how the Commonwealth encourages states, if we're really going to wait for all of the 8 state and territory jurisdictions to do a few bits of legislative tidying up. That seems kind of cumbersome. But nobody's responded to what's in our papers about the fact that the UK in negotiations with us on the trade agreement made it quite clear that they were surprised that we hadn't ratified it and expected that we would. I'll make the reference here. It says here in Chapter 21 of the recently signed but not yet ratified Australia-United Kingdom Free Trade Agreement, this is in the text. The parties underline the importance of ratification of the Protocol of 2014 to the ILO Forced Labour Convention, etc. And the United Kingdom recommended, the United Kingdom itself, in the 2021 UN Human Rights Council periodic review, the UK took the step of, in its review and comment on our human rights record, of noting that we should ratify the protocol. So it's clearly something that the UK noted about our standing in human rights terms as part of that review in 2021, and then it's listed in the agreement, the trade agreement that we have settled but not ratified, which just to sort of further emphasise the point. So I don't think there's any doubt that the fact that we hadn't yet ratified it was something that had come to the attention of the UK, and they felt that it was a sort of a shortcoming in our record that needed to be addressed. And they wanted that. Not only did they make that comment through the Human Rights Council periodic review, but they've made sure that it's noted in the trade agreement that we've just signed.
Thanks. Ellie Parlow here from the Attorney General's Department. We will note that the Attorney General first, or in her former role as Minister for Employment, first announced Australia's intention to ratify this back in 2017, and since that point we have been taking active steps to ratify the protocol, just as my colleague Lani Rankin mentioned before, had a few compliance issues, including at the Commonwealth level, to address before we could. So this process was already in train prior to the UK FTA.
Sharon from the AGD, I would say that we have been waiting for Western Australia. As soon as that was done in December, we have acted immediately to seek to have the protocol ratified, and that has been the overriding reason for ratification. As my colleagues have said, the Minister announced in 2017 that we would do so, and that we have acted as soon as we've been compliant, as is custom and practice within Australia for ratification.
I understand that. I have people reluctant to acknowledge that it was raised as a shortcoming by the United Kingdom.
It's certainly not been our focus.
What does that mean?
It means that we've been waiting for compliance with the protocol, for Australia to be compliant. I'll hand over to DFAT, I think, made a comment there.
If I could, sorry, Lucienne Manton, Ambassador, People Smuggling and Human Trafficking. I would just want to highlight the very, very close relationship Australia and the United Kingdom have on the sorts of issues that you raise, human trafficking and modern slavery, including engagement that I closely have with my counterpart in the UK's Foreign and Commonwealth and Development Office. And I know that our colleagues in the Australian Border Force also have really close engagement with the United Kingdom that has a similar approach on a number of these issues through their own Modern Slavery Act. And I would just like to highlight that the Australia-UK FTA Labour chapter is indeed our most comprehensive to date, and that for the first time in Australian FTA practice includes a dedicated provision on modern slavery, including efforts to ensure the parties' private and public sector entities take appropriate steps to prevent modern slavery in their supply chains. So I would just say that we're really closely engaged with the United Kingdom on this, and that we have they would be very aware of our position and the progress in relation to this particular protocol. Thank you.
Not sure I'm really getting an answer, but thank you. Thanks, Chair. That's all from me.
Sorry, Mr. Wilson. Senator Cox is on the call. I believe Senator Cox had some questions.
Thanks so much, Chair, and thanks to all the witnesses for appearing today. My question really was just around the measures that the Australian government have implemented in relation to addressing forced labour in Australia, and I mean, understanding what the effectiveness of those have been. Is there any evidence that can support that around the current policy interventions that we have?
Frances Finney from the Australian Border Force. I think in terms of the comprehensive criminal framework through the Criminal Code Act, there were some statistics that were reported earlier in regards to reports to the AFP. There are also further statistics in relation to convictions and prosecutions as well. If I might just share some of those to start with. In terms of prosecutions, in terms of total prosecutions for modern slavery, which would include forced labour, there are currently, for the calendar year 2020, there are 4 new prosecutions and 20 that have been continued. And for the calendar year 2021, there are 3 new prosecutions and 19 being continued. In terms of convictions by number of individuals, for forced labour in particular, between 2004 to 30 June 2020, there have been 3 convictions, and in the calendar year 2020, there's been a further 1 conviction. And that's just with respect to forced labour in particular, but there are other modern slavery offences that, such as trafficking and so forth, that are also being pursued. So in terms of the effectiveness, the criminal framework does provide for effective action and disruption and to address these practices in Australia. But in saying that, there is further work that is being done and needs to be done that is captured under the National Action Plan to Combat Modern Slavery from 2020 to 2025. One of the things that has been of interest is some work that has been done by the Australian Institute of Criminology around attrition in the actual reports of forced labour and other forms of modern slavery, and the attrition that occurs between the reporting and then actually going through the process to prosecuting and then convictions, and some of the underlying reasons why some of those things may, why some of those reports may not be all being prosecuted and convicted. And so research such as what the AIC has done is enabling agencies and civil society who we work with to look at how can we make this more effective, how can we make this, the criminal framework that's in place actually have some more impact in terms of disruption and prosecution. I might just check if okay with my AFP colleagues and also my other Border Force colleague if they wish to add anything to that.
Thank you, Frances. Hilda Sirik here from the AFP. Absolutely acknowledge everything that Frances has said. Generally, in our experience, perpetrators of human trafficking and slavery, including forced labour, can be highly sophisticated, and they change their methodologies to evade detection, investigation and prosecution. The ability to prosecute human trafficking and slavery relies on first-hand victim testimony to prove the elements of the offence, and the access to the cooperation of suspected victims is therefore essential to being able to prosecute these offences. It can be difficult to secure where a witness is offshore as well, as they may be unable or unwilling to participate. And victims are often, in our experience, reluctant, unwilling or unable to self-report to assist investigations and prosecution processes. And this may be because of fears of retaliation or because of mistrust of authority, which is often perpetrated by the employers to control a victim and prevent reporting. Where they are willing to participate, the victim's trauma can often affect their ability to engage effectively with the criminal justice process. And in respect of other forced slavery offences, such as forced marriage and other human trafficking offences, perpetrators are often family members or members known to the family or a part of the community, making them reluctant to be able to assist with investigations. Thank you.
Thanks, Chair. Commander James Watson. I'm the Commander Maritime and Enforcement South. Just in further to that, At an operational level, the ABF is very closely involved with working with all of our partners. And what, in particular, one of the key aspects here is our human trafficking contact officer regime that exists around the country. And that provides a source of expertise to our field officers who are often out there checking on workplace conditions, visa compliance, making sure that those that are sponsoring visa holders are doing so properly, that those arrangements are in place. So by being in the workplace, by being in the field, what the ABF is able to do is to effectively put eyes on to areas where there may be concern, or where there might be indicators of trafficking, slavery or forced labour, etc. So our field compliance officers receive training through internal training. Every ABF officer that starts in a recruit program here undergoes a program of training where we arm them with sufficient knowledge to be capable of looking for signs of those trafficking, slavery, forced labour and so on. They then are in the field. They're able to then come back to a human trafficking contact officer who has had more training, often worked with the AFP and other law enforcement agencies, and they're able to, in a sense, Chair, able to understand what it is that might be capable of being referred for criminal action. Of course, we also work with Fair Work Ombudsman, and throughout the range of activities that we see whilst we're in the field, are able to try and refer that to the most appropriate organisation. Other places that the ABF can routinely get information which might lead us towards concern about what is happening in certain patches is through our sponsor monitoring unit. So those employers who sponsor visa holders to come on shore, we need to make sure that those visa holders are that those sponsors rather are upholding their conditions with respect to those employees. We also receive a significant number of referrals from the public or from industry through our Border Watch program. And again, what our Border Watch program does is allows us to then look in using our departmental systems to determine if we can provide any more information that might enable a referral to the AFP or to an appropriate agency. Clearly, working with state and territory police and the Department of Home Affairs is another source of information. So all of those areas are designed with our ABF officers to be able to, whilst undertaking their duties around visa monitoring, sponsor monitoring, to be able to identify and look for those signs of trafficking, slavery, forced labour, etc., asking the right questions and making the referrals. And it's through that process of working with the AFP and in particular Fair Work Ombudsman that we are able to do that. I should indicate, just as a matter of course, that there are very tight referral protocols that are in place around this. So where we see evidence of in the field of somebody who is at immediate risk of slavery or like offences, our obligation is to deal with that immediately, and then within 1 hour to have a referral to the AFP. It cascades there from throughout a reporting arrangement, but I suppose the point to make there is our threshold is deliberately set very low because we want to make sure that our colleagues are certainly aware of what we're seeing. Thanks, Chair.
Chair, I've just got a couple of follow-up questions to that.
Yeah, go ahead, Senator Cox.
In light of that, then would you characterise the approach that we currently have as combating the structural drivers of forced labour, in particular focusing on assisting victims in this instance?
Yes, Frances Finney from Australian Border Force. I might start on that. Under the National Action Plan to Combat Modern Slavery 2020 to 2025, one of the key priorities is taking a victim-centric approach to all of the work that is done to combat modern slavery, whether that be through the disruption efforts as just described, or in also looking to improve our opportunities to engage with victims and survivors directly in shaping the response to combating modern slavery going forwards. And then in terms of support, I might pass to my DSS colleague just to explain a little bit more around the support that's provided to victims and survivors and how that is a very important part of the response.
Thanks, Frances. Greta Doherty, Branch Manager from Women's Safety Policy in DSS. So the Department of Social Services is responsible for managing the Support for Trafficked People program, the support program. And the support program exists to assist all eligible victims of human trafficking, slavery and slavery-like practices that are referred through by the AFP. As Frances mentioned, the focus really is on a victim-centred approach to support. So under the program, eligible individuals get tailored case-managed support, offering things like safe and secure accommodation, access to medical treatment and counselling, referral to legal and migration services, skills development and any other social support that individual and if they have dependents, that their dependents might need. The period of support depends on the way that an individual's case might be progressing through the legal and justice system, and there's a range of sort of streams of support available from an initial assessment and intensive support sort of initial piece through to longer term support where a process might be proceeding through the criminal justice system and might take some time. That tailored support is available to the individual for the duration of that period. Thank you.
Chair, Commander James Watson, just further to that answer, at a very operational level where Australian Border Force officers are in the field and they come across circumstances where somebody might be a victim of or a survivor of trafficking or slavery or forced labours, and in circumstances where they do not hold a valid visa to be on shore. It's one of the things that our officers can do is to have the power to grant a visa, obviously, to regularise that status immediately. So our officers are trained when looking at this right up front to be able to take one of the worries out of the survivor's mind, which is to consider just making sure that they're lawfully based on shore. Thanks, Chair.
And Hilda Siric from the AFP, Senator Cox and Chair. And just to complement the work already been explained, the AFP also recognises that first responders are likely to encounter indicators of human trafficking and modern slavery in the course of their duties. So we aim to equip them with the skills necessary to identify and respond to these indicators through the prevention and awareness program called Look a Little Deeper. And we create these training sessions to all state and territory police, Commonwealth government agencies, including Royal Australian Air Force members who deploy offshore on humanitarian aid missions, state government agencies, universities, non-government organisations, community group peak bodies, and modern slavery community of practice and the Fintel Alliance. And across Australian Border Force, DSS and all our Home Affairs colleagues, we also work very closely with other support services such as Anti-Slavery Australia, who offer dedicated support to victims across the whole spectrum of human trafficking and modern slavery. Thank you.
Thanks, Chair. That's all the questions from me.
Hey, Senator Cox. Mr. Wilson or the Deputy Chair, any further questions from you? Mr. Broadbent, any questions before we conclude? If that's the case, I'm going to take it that there are no further questions from anyone on the call. All right, if that's the case, I'd like to thank all the witnesses from the numerous government departments and agencies represented here today for your time on the call and your submissions to this inquiry. If you could, if you have been asked to take questions on notice, I'm aware of at least more than the ones I asked concerning ratification of the protocol. Could you please do so, take those on notice and get them to the Secretariat promptly? Secretariat, when do we need responses to questions on notice by?
5 working days in this instance, please.
5 working days, okay. So that's by Friday next week?
Friday next week.
Okay, yeah, so if you could provide any responses to questions on notice by Friday next week. You will be sent a copy of the transcript of your evidence when it becomes available, and you will have an opportunity then to request corrections to any transcription errors. I now declare this public hearing closed and ask witnesses to disconnect from the video conference, and committee members are asked to remain if they can, please, for the private meeting.